Confidentiality is the foundation of trust in business. Whether you are starting a company, hiring employees, or negotiating a deal, protecting sensitive information is crucial. That is where an NDA non-disclosure agreement comes into play. But how do you draft an NDA that is legally sound and effective? Today, I will walk you through the step-by-step process of drafting a strong NDA, explain its key clauses, and share some lesser-known legal insights that can help you avoid loopholes. Stay tuned. An NDA, a non-disclosure agreement, is a highly legally binding contract between two or more parties that restricts the sharing of confidential information. This agreement ensures that sensitive details such as trade secrets, financial information, or business strategies are not disclosed to unauthorized parties. Real life example. Imagine you are a startup founder discussing a new app idea with investors. If they walk away and develop a similar app themselves, you might have no legal ground to sue them unless you had an NDA in place. There are two types of NDAs. Unilateral NDA, one party discloses information and the other agrees to keep it confidential. Example, employer-employee agreements. Second, mutual NDA. Both parties share confidential information. Example, two companies collaborating on a project. The hidden insight here is, did you know that in India, NDAs are typically governed under the Indian Contract Act 1872? Unlike in the US, where NDAs can impose heavy monetary penalties, Indian courts focus on injunctive relief, meaning stopping further disclosure rather than awarding massive damages. Identification of parties. The first step in drafting an NDA is clearly identifying the parties involved, who is disclosing the information and who is receiving it. Be specific. Use full legal names, company names, and addresses. Example, this agreement is made between ABC Private Limited, hereinafter referred to as the disclosing party, and XYZ Technologies, hereinafter referred to the receiving party. Definition of confidential information. What information is considered confidential? Be precise as possible. Examples of confidential information: business strategies, financial records, client lists, trade secrets, future product designs. However, if you keep it too broad, courts might rule your NDA unenforceable. Avoid vague terms like any and all information related to business. Instead, list specific types of protected data. Many people don't know this, but if an NDA does not explicitly state what is confidential, Indian courts often refuse to enforce it. Clarity is key. What can and cannot the receiving party do with the information? Typically, they must keep the information secret, not use it for their own benefit, nor disclose it to third parties. Example clause. The receiving party agrees not to disclose, reproduce, or use the confidential information for any purpose other than the stated business purpose without prior written consent. How long should confidentiality last? If the NDA does not specify a duration, courts may consider it invalid. Best practice: for trade secrets, confidentiality lasts indefinitely. For business negotiations, 2 to 5 years is common. Example, the receiving party shall maintain confidentiality for a period of 5 years from the date of disclosure. Some companies make a huge mistake by keeping an NDA indefinite. Courts sometimes rule indefinite NDAs as unreasonable restraint of trade. Always set a reasonable duration. Exclusions from confidentiality. Not all information can be confidential. If something is already public or legally required to be disclosed, an NDA cannot cover it. Example exclusions include information already in the public domain, information received from a third party without restriction, information disclosed under legal obligation. If your NDA does not have this clause, it could become unenforceable. Enforcing an NDA. What happens if someone breaks an NDA? If someone leaks confidential information, the disclosing party can take legal action. The most common legal remedies include: first, injunctions. Court orders stopping further disclosure. Second, monetary damages, compensation for financial loss. And third, reputation damage. The guilty party may face loss of business credibility. In India, monetary damages are rare in NDA breaches. Instead, courts focus on stopping further harm through injunctions. So, how to strengthen an NDA? Many NDAs fall in court due to poor drafting. Here are some tips to strengthen your NDA. Include a specific jurisdiction clause. Specify where disputes will be resolved. Example, Delhi High Court. Add a liquidated damages clause. Set a pre-agreed compensation amount in case of breach. Use non-compete and non-solicit clause. Prevent employees from using confidential information to start a competing business. Did you know that non-compete clauses in NDAs are often not enforceable in India if they go beyond employment duration? Courts prioritize an individual's right to earn a livelihood over business protections. Comparing NDA laws, India versus US versus UK. India, governed by the Indian Contract Act 1872, enforced mainly through injunctions. Non-compete clauses are mostly unenforceable. US, more aggressive enforcement with heavy fines. Companies use liquidated damages to preset penalties. UK, similar to India, but courts consider reasonableness. If an NDA is too broad, it may be invalid. A well-drafted NDA can save businesses from financial losses and legal troubles. By understanding the essential clauses and the legal nuances, you can create a strong, enforceable NDA. Remember, clarity is key. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights. Let me know in the comments if you have any questions about NDAs or contract drafting. See you in the next video.